Yes, my people, I don't come again to bring the update for wetin dey go on now for Supreme Court concerning the case between Atiku, Peter Obi and Tinubu. So right now, e don dey set as we dey talk now. As I dey talk to you now, things are already going on inside the Supreme Court. But I no wan talk too much. I felt make una promise say yes. As the update dey fall out, na so me I go dey bring am here for all my fans to dey updated. So as e dey hot and as e dey go, don't play, stop playing. I wan bring up the video make una see the update wetin dey go on now for Supreme Court as I dey talk. So right now, as I dey bring up the video so, I take God name beg you, anywhere you dey watch this video now, make sure say you go like, comment, very important, share am, so that for those of us wey never see the update wetin dey go on for Supreme Court now, make una hear wetin dey go on now. Thank you.
Having also found that no merit exists in all the above three consolidated petitions, I join my learned brothers and Mani Jesse in dismissing all the three petitions and abiding by the consequential orders made in the lead judgment.
Dissatisfied with the verdict of the Presidential Election Court on September the 6th, the three appellates, Atiku Abubakar of the People's Democratic Party, Labour Party's Peter Obi, and the Allied People's Movement, filed the appeals urging the Supreme Court to nullify the victory of President Tinubu. In the 42-page notice of appeal filed by 18 senior advocates and 47 lawyers, the former vice president anchored his appeal on 35 grounds. Amongst other things, the PDP candidate held that the lower court erred in law when it refused to uphold as mandatory electronic transmission of results for confirmation and verification of final results as introduced by the Electoral Act 2022 for transparency and integrity of results. In another ground of appeal, the appellants argued that the lower court erred in law when it failed to determine their case with respect to the mandatory verifications and confirmations required before the announcement of the result of the presidential election. They also faulted the lower court for its interpretation of the use of the word and the FCT in relation to Section 134(2)(b) of the 1999 Constitution. The appellants also touched on the issue on the use of what it called disparaging words by the court against Mr. Atiku Abubakar and the PDP, which they termed as indication of bias and which violated the rights of fair hearing and occasioned grave miscarriage of justice. In the final analysis, Mr. Abubakar and his party urged the Supreme Court to set aside the judgment of the Presidential Election Petition Court to declare that President Tinubu is not the winner of the polls, was not even qualified to contest the polls, and to instead declare the PDP candidate as the winner of the polls, or in the alternative to order INEC to conduct a second election between him and President Tinubu. While this was pending before the court, Atiku Abubakar on October the 6th filed new documents seeking the Supreme Court's nod to present a deposition on oath of the registrar of the Chicago State University concerning President Tinubu's academic records. Mr. Abubakar is questioning the authenticity of the president's academic certificate submitted to INEC, alleging forgery of the document, and seeking that he be disqualified and removed from office. The Labour Party and its presidential candidate on their part filed a 73-page notice of appeal. The document, which was filed by 13 senior advocates and 25 other lawyers, was anchored on 51 grounds. Among other arguments, Mr. Obi and the Labour Party said the Presidential Election Petitions Court erred in law and reached a wrong conclusion when it dismissed the petition he lodged to challenge the outcome of the presidential election. He maintains that the lower court carried out a miscarriage of justice against him when it held that he did not specify polling units where irregularities occurred during the election. Mr. Obi also accused the panel of erring in law and striking out paragraphs of his petition, dismissing his witness as incompetent, a situation which he says breached his right to fair hearing. The APM, on its part, has insisted that President Tinubu contested the presidential election without a lawful running mate. The party said that the withdrawal of Ibrahim Masari and the expiry of the 14 days permissible for changing or withdrawing candidates under Section 33 of the Electoral Act 2022 made President Tinubu's election and return invalid. There's been lots of speculations as to the composition of the panel to hear the appeal, and all eyes are on the Supreme Court to do justice in the three appeals before it.